வணக்கம். சைசி இன்னைக்கு ரொம்ப முக்கியமான ஒரு டாபிக் எடுத்துட்டு இருக்காங்க, ப்ரூவிங் ஆஃப் எலக்ட்ரானிக் ரெக்கார்ட்ஸ். இந்த மாதிரி ஒரு கான்ஃபரன்ஸில் என்னால் நேரம் வர முடியலன்னு எனக்கும் ரொம்ப வருத்தமாக இருக்குது. ஆனால் இது மாதிரி ஒரு ரெக்கார்டிங் மூலமாக என்னோடய மெசேஜை ஷேர் பண்ணுறதுக்கு ஒரு ஆப்பர்ச்சுனிட்டி கொடுத்ததுக்கு மிக்க நன்றி. Electronic evidence. So the minute we think about electronic evidence, there is an automatic resistance. Just the prefix electronic somehow seems to create an obstacle in our mind in terms of accepting such evidence, or there is a fear in terms of reliance on such evidence. There is an automatic assumption that the minute it pertains to the electronic domain, somehow it is more difficult to rely on rather than a very safe and easy form of evidence to place reliance upon. Now, this reluctance would ideally have been set aside through the mechanism of law. Law here definitely needed to be an enabler and not a stumbling block. This was in a way the earnest request that the Arjun Pandit Rao judgment also put forth. There was a clear direction and guidance to the legislature in the judgment, which first talked about the genesis of 65A and B, which were primarily from the civil and criminal laws from the United Kingdom. Our Supreme Court first enumerated the UK provisions and the fact that both the civil and the criminal provision had been repealed as of 1999, and UK resorted to common law principles for reliance on secondary evidence with respect to electronic records. And there was a clear direction that India could also probably follow suit. And most importantly, even if we step back a bit from the main Arjun Pandit Rao judgment to the reference, what it earnestly put forth is for clarity and certainty in terms of reliance on electronic records. So with the new laws coming into place, what we would have safely assumed or presumed as something that we could expect was that certainty and that clarity which a catena of judgments had set out to enumerate and elaborate and clarify the rather ambiguous provision as was available to us under 65A and B of the Indian Evidence Act. Unfortunately, what we have today may be a slightly modified version, may be an attempt in good faith to provide that clarity, but unfortunately it falls short. To what extent does it help us and to where does it fall short is something I would like to at least try and briefly touch upon in my session. And I do not expect to be able to enumerate in detail on all aspects. So I limit it to the fundamentals here, and I leave it to today's deliberations to delve deep into this topic. And most importantly, try and give some clarity for practitioners so that whatever we have on hand today is easy to implement, and we hope that swiftly law will take some recourse to making electronic records the best form of evidence. That is our utopian dream. Let us see where the journey has been till now and where it leads us. I would not be taking much time on the journey so far, but I would like to first emphasize on what Arjun Pandit Rao said and a little bit about my journey in terms of my contribution before the Criminal Reforms Committee and as an advisor to one of the ministries. So if we look at Arjun Pandit Rao first, as I already pointed out, it emphasized the need for certainty and clarity for reliance on electronic records. It affirmed the main decision affirmed Anwar versus Bashir on two things. One is that if you're relying on primary evidence, then you do not need to give the certificate. So if you look at the Bharatiya Sakshya Adhiniyam, and I would like to use a shorter form of BSA for the rest of the session. So if you look at the equivalent of 60 under the Indian Evidence Act, you have Section 57 BSA, which not only talks about primary evidence, but it has been elaborated a bit further to include electronic records or primary evidence with respect to electronic records, where you produce the device or the computer on which the primary document or record has been created. There clearly the necessity for the certificate is not needed, and that position continues under the BSA also. So moving forward, and I would like to emphasize a little bit about the provisions for secondary evidence here before we move on to the special provisions. The reason for this is something I very earnestly presented before the Criminal Reforms Committee and have advocated thereafter too, which is, do we really need special provisions? Set aside the fact that we drew from UK provisions, set aside the fact of the earnest guidance that the Supreme Court has repeatedly given in terms of what is needed or what is not, or what is missing, more importantly, in terms of proving of electronic records or the provisions there too. If you look at the secondary evidence provision simpliciter, under the Evidence Act earlier it was 63 and 65, and you have similar provisions incorporated under 58 and 60 now. You will see that predominantly substantial subclauses under these two provisions take care of electronic records also, or secondary evidence of electronic records. So if you're relying on a printout or some other form of a copy of an electronic record and you need to rely on it, the process of mechanical reproduction, the process of having verified one with the other, the process of being able to prove the integrity of the secondary evidence as being the same as that in the primary evidence, or the contents be remaining the same, and the methodology that has been set out under BSA now too, under 58 and 60, would have very well helped us in terms of proving electronic records also. However, for reasons best known to them, the legislature has continued to bring in the special provisions. It has ignored a lot of lacunae that was already pointed out in the old provision and retained it as is, and I will briefly touch upon those aspects too going forward. And the additions, I wouldn't say all the additions under 63 are inane or insufficient or not essential. I would say some of them are very critical and it helps us, but substantially, what was our expectation, which is that any law which may be provided for proving of electronic records would ease, would facilitate the process and will not become an obstacle. Now that expectation unfortunately is what is not met. So let's delve a little bit in depth into the provision, and I'll primarily focus on the preliminary aspect and rely on the totality only to give it context. So when we move forward from the very first, and as I said earlier, if you're relying on the original, then you do not have to enter into the certification process. Just production of the original is sufficient, and you will recollect that this was what we saw in Anwar versus Bashir also. 61 is a new addition, and it primarily talks about the admissibility of an electronic or digital record on par with any other kind of document. So it's more of a clarificatory process and an affirmation rather than laying down anything new or substantive. 62 again is the equivalent of 65A, and it merely talks about the admissibility of electronic records in accordance with the provisions under section 63. So for you to rely on the computer output, which is defined under 63 as anything that's printed on paper or stored, recorded or copied in an optical or magnetic media, and this is what we had under 65B, then 65A was just the enabler in terms of relying on such computer output provided you complied with the conditions under 65B. Now, what do we have under 63(1), which is the equivalent of 65B1, right? You have some small additions. The most obvious which you would see is a delineation of communication device from a computer. Now, if you look at the way interpretation followed on computers earlier, a communication device was also considered as part of the definition of a computer. By way of abundant caution, or so it appears, there is a very specific addition with respect to communication device under 63 BSA. So this is an addition you will see in each of the subclasses. Now there is one more addition in 63(1), which I would say is a bit critical, which is, of course, one more addition, of course, is apart from optical and magnetic media, they also talk about storing from the original electronic record onto a semiconductor memory also is considered as a computer output. But it also goes on to add, or otherwise stored, recorded or copied in any electronic form. So in a way, I would say this is an addition intended to provide some dynamism in terms of some other new forms of recording or copying or storing, which may not necessarily be available today. And I would therefore say that's a good addition there. So this is what section 63(1) gives you, which is that clarification in terms of what is it that would require the certification process. So it's effectively like a build-up from 1. I would say actually we should jump to 3 and then move to 63(2) and then 4. That's how the flow actually comes. And in effect, I would also say 63(2) could have been subsumed into 63(4), given the manner in which the wording is again retained from 65B, and where courts have already pointed out the opacity in those provisions. I will clarify as I move forward. So when you look at 63(1), I'm circling back to that, and what it entails, I just want to put in a qualifier. Often the wording that is contained here has been misconstrued as if everything about an electronic record, including the truth or correctness of the contents, stands proof once the certificate is accepted and the document is marked. That is not the case. As with any other document, it is only about these 3 fundamentals which the certificate helps us to establish, which is the authenticity, integrity and non-repudiation. And the last part is what a party which is contesting the certificate or the document submitted along with it will be raising. That is, where they want to repudiate a document, and they will do so by attacking the authenticity and integrity of that document. If you look at the opinion of Justice Ram Subramaniam in the Arjun Pandit Rao judgment, I would say it's a fascinating enunciation in terms of proving of documents itself per se, and specifically with respect to electronic evidence. I would strongly advise all students, certainly, and also practitioners to go through this opinion, and it remains relevant as on date 2. The new laws have not really substituted the necessity of this particular opinion. So what it talks about is the 3 stages in terms of proving of documents. The first stage, of course, is relevance, and the second stage is the proof or the admissibility of it. And the third stage is the proof of the contents, as in the truth or correctness of the contents. So when we're talking about the certificate, we are actually only talking about the second stage, which is the admissibility part of it. It doesn't refer to the relevance part of it, because that would be before the certificate aspect. Then you come to the necessity of the certificate and how you're going to prove it and why. And the third stage will be you will still have to prove the truth of the contents. If I were to enumerate a little bit more on that, if I were to send you an email saying that you owe me 1 crore rupees, and I assume that as somebody who knows not just 65B but now 63, I will be able to submit a proper certificate and have certificates, I'll have to say now, and have that email taken on record. Does that mean you owe me 1 crore? Not really. I would still have to prove that you actually owe me 1 crore. Why do you owe me this money, and how, what is the transaction behind this debt, etc. Right? So that's what I mean by the third stage. So we are really limited only to this threshold level of taking that document on record. So in this context, if you look at the new provision and the additions, certain things lend, I would say, clarity, right? One, as I said, I would rather read 3 first and then move to 2, because if you look at what is the purpose of subclause 3 of 63, you will realize it is actually just an enunciation or an elaboration of what amounts to a computer or computer resource. So it talks about how a standalone computer, a computer system, network, or a resource, which could be even a cloud or an intermediary, would all amount to a computer. Which means if you have a series of computers and either one or multiple computers are recording something, all of it comprehensively or severally will amount to a computer, and you could draw from either any of those to submit your computer output. Computer output, as I already explained, is something which is a copy of what is there in the primary electronic record source, wherever it may be. So this elaboration in 3 helps us to a lot, to a substantial extent, and more so I would say with the simplification of the explanation. And this is the substantial addition that's made in subclause 3. And that helps us when you go back to subsection 2 in terms of what is it that you're expected to do. Now, when you look at subclause 2, it remains the same except for the substantial addition of the words communication device. One critical aspect also comes in terms of subclause 2A, which is the addition of the word create. Earlier you had a computer used regularly to store or process information for the purposes of any activities regularly carried on over that period by the person, etc. Now it also includes create, store, or process. Now in hindsight, when you look at it, you can see that it seems like an obvious addition and something that ought to have been there. More so when you look at subclause 2 itself, which seems to be talking about the creation of a document, and that to show that it was created by a computer device, and that during that period the computer device was working properly and it was used for that particular activity, and that there was no disruption which damaged the integrity of the document, and even if there is a disruption, it did not damage the integrity, and that the information contained in the electronic record reproduces or is derived from information that's fed into a computer system. Now I will just pause here to just clarify one aspect which again both Anwar versus Bashir to some extent and Arjun Panditrao in more elaborate manner enunciated, which is that when you look at the first 3 subclauses, it doesn't give you an indication of whether it is or and. But between C and D you have an and. So the subclause 2 has been interpreted as if you have to comply with all 4 conditions. Now here was an opportunity for legislature to clarify, and this becomes critical when you look at subclause 4, and I would also request you, if time permits, for you to read this one article I wrote for Live Law where I spoke about the tale of 2 NEs, 2 ANY, NEs, and from Anwar to Arjun. So why I'm asking you to read this is, if you look at subclause 4, in the beginning, the first preliminary part of it, it says that you have to give the certificate doing any of the following things. Now that wording has been retained in subclause 4, some specificity in terms of when a certificate is to be given has been included in subclause 4 through the wordings of that it shall be submitted at when an electronic record is being submitted for admission. So to some extent, this clarity comes in terms of at what stage do you have to give the certificate. But the word any of the following has been retained. What exactly do they mean by any of the following? The subsection then goes on to enumerate the three things are to be done, which is you identify the electronic record and how it was produced. Secondly, you also give the particulars of the device used for production of that electronic record, and here is where they have linked it to subclause 3 in the new edition under subsection 4. And then the third part is important, which is that it asks you to describe any of the matters in terms of the conditions set out in subclause 2. Now, in two places in subclause 4, which is where a certificate is mandatorily required to be submitted, it talks about you having to submit on particulars, which is only any of the three. But if you read the subsection along with the interpretation in Arjun Pandit Rao and Anwar versus Bashir, of course, moving forward also to, most importantly, the format that has been given to you in the schedule, you will realize that again, you will be required to prove all 6 conditions and not just any one of the 3. Why am I saying 6? Because under subclause 4, you have 3 elements where first 2 set out 2 separate elements and the third subclause only talks about any of the conditions set out in subclause 2, and subclause 2 sets out 4 conditions. So now therefore you will have to continue to give also you have to comply with all 6 conditions set out in 63. This again goes on in the same way as under 65B. The opportunity that the legislature had at least to clarify and not use the word any has been missed. The good thing, of course, is the schedule has been added and the format is explicitly given. Where is the bad news here in subsection 4? We already had difficulty in terms of proving electronic records either through owner or administrator or a person who was in charge of the management of the activities. But now you need 2 certificates to be given. The first is by a person in charge of, and there is a slight correction from 65B to 63 here, or I should say amendment. So a person in charge of the computer or communication device or in management of the activities. Now, if you look at all the judgments, nothing really enumerates on what do they mean by activities. Here was an opportunity to explain it. Again, that has been missed. Nothing has been explained. And here is where the problems start. So you now have to give a certificate by a person in charge of the computer or communication device or of the management of the activities and of an expert. So every time for every electronic record that you wish to rely on, now you have to give 2 certificates, both of the owner or the management person and of the expert. Now this is not really a facilitation, it just complicates it further. If you look at the schedule, the good thing there, of course, as I already said, is it gives you the format of how you can give the certificate. I remember early days, the maximum number of queries I would get is about this aspect. How should a certificate be formulated? Should it be in the form of an affidavit or just a certificate form, etc.? So having this kind of a practice direction helps people in terms of submitting the certificate. However, one very critical addition there, and possibly that could be the reason why the expert has been added, is that the certificate should also set out the hash value. Both the owner or management person certificate as well as the expert certificates mandates necessarily the inclusion of hash value. So therefore, the positive of that is there is automatically an inbuilt methodology through the section as well as the schedule to ensure that the court has before it a certificate that assures the integrity of the document. But at the same time, it also complicates it because you now have to get two persons to certify to something, which if you had followed the secondary evidence route, you may not necessarily have had to do. There, you could have still proven the integrity of the document through the normal means which you would adapt for any other document. Now, this is something which we'll have to wait and see how difficult or easy it's going to make our life. Now, when we talk about two persons having to give the certificate, the issue will also arise about the submission of those two persons to evidence. Often we have noted that the person who has given a certificate may not be available thereafter for proving the certificate, for getting that certificate even admitted. So if you look at the Ramajayam judgment from Madras High Court, it helped in a way in terms of clarifying that you do not have to take the statement of the author of the certificate in evidence, as in you do not have to subject the author to cross-examination unless the integrity or authenticity of the electronic records which the certificate covers are being contested by the other side. But the qualifier here is, and I'm sure this is a question that will pop into your minds, the Arjun Pandit Rao case overruled Ramajayam. But if you read the judgment, it's very clear that it is with respect to the specific ratio that Ramajayam set out, which is that aliunde, if you are submitting an affidavit of evidence and that sets out the requirements of 65B, then a separate certificate is not needed. This aspect was overruled in Arjun Pandit Rao, which said, sorry, just the evidence, chief examination in the form of an affidavit will not suffice. You will have to give the certificate separately. So the aspect with respect to the necessity of submitting an author to a cross-examination may still continue, and we will have to see to what extent the courts are going to decide upon now the necessity of submitting two witnesses, not just one, for cross-examination. The assumption would be predominantly the defense will deny the documents and you would have to bring the witnesses for cross-examination. Some succor comes to you from one of the Bombay High Court judgments where in a company A had given the certificate and then he had moved on, and then B gave evidence. So he spoke about both the electronic records and also with respect to how the certificate was given. And in those circumstances, the Bombay High Court still allowed for that evidence to help take the certificate on record. Again, these are issues still which are moot, and we'll have to wait and see how the new provisions pan out. Moving forward, subclause 5 does not give you much difference in terms of what we already had. It primarily brings in some minor corrections in terms of simplifying the language, and that's more of an explanatory subclause. Now, when we look backwards to what we could have had and what we have today, I would like to close by relying on the Madras High Court judgment in Yuvraj versus State, which came very close to the new laws being enacted. I would say just before it came. Very poignantly, the Madras High Court says that 65A and B are a square peg in a round hole and it doesn't fit quite well. And it also laments the fact that whilst UK decided to do away with the special provisions for certification, India adapted it thereafter, meaning in 99 UK repealed these provisions and India adapted it in 2000. Another very interesting aspect comes out from the Madras High Court judgment, which is it points to countries such as Canada and South Africa, which decided on a separate code for electronic evidence. So the court also advocates that possibly we should also resort to a separate section at least for electronic evidence and not combine it with the primary and secondary evidence aspects, even though what we have now are special provisions which are meant to set out separate procedures. Now, we already have a lot of difficulty as practitioners in terms of proving electronic records. The difficulty is aggravated if there is insufficient training for police officers in terms of substantially establishing prosecution cases. Now, this aspect has been highlighted by the Supreme Court in William Stephen versus State of Tamil Nadu. I thought it was really critical as we move forward for not only special training to be given to police officers. I'm aware that this process has started quite some time back and continues till date, but we need to give special emphasis to ease the fear which I mentioned at the very beginning in terms of either the word cyber or of electronic, and give confidence to our law enforcement officers that they can definitely rely on electronic records. They can find an easy methodology provided they put down clear SOPs and a process-driven methodology to ensure that electronic records are taken on record. Today, as opposed to earlier instances, they have a very specific format, and one criticality about the format is it not just talks about hash value, but it actually gives like a tick mark methodology for you to decide and figure out who you're taking that certificate from. So the categories from whom you can take the certificate are also clearly set out there. And therefore, to that extent, you have a less complicated process. I will not move further on the complications that are going to arise in terms of the word expert in subclause 4. I'm going to leave that for the next IC conference. Thank you all once again for having me here. Jai Hind.